Hello, and welcome to the latest of our HR Insights webinars. We're continuing with our theme in respect of what the Employment Rights Act that's progressively being introduced will mean for employers and what we should be doing about it now. I'm Hilary Aldred. I'm a partner in the team, and I'm being joined by Laura Nichol, who is one of our senior associates in the team. And this time we are going to be discussing fire and rehire, which didn't used to get called fire and rehire, but has become the watchword for how one goes about dealing with the process of dismissal and re-engagement. Fire and rehire obviously first came to wider attention following the P&O issue a few years ago. It was always dealt with before then, and most employment lawyers, when P&O happened, thought, well, that's not the best way to go about doing it, but it was a fairly common pattern and technique if you couldn't move through employees to change their terms and conditions of employment. However, ending fire and rehire had become a cornerstone of the Labour government's election manifesto. And whilst there have been some changes to the original proposals, not quite as many changes to those proposals as there might have been to unfair dismissal, it is designed, and the new law is going to make it much, much more difficult to dismiss an employee and offer re-engagement on new terms where those new terms might be to the employee's detriment. Just by way of reminder, and we will go through where we're at the moment, we did have a statutory code of practice introduced by the previous government setting out what steps an employer should take when they were dealing with dismissal or re-engagement process, where that has already been in force. This code of practice is still in force, and it at the moment gives power to the tribunals to increase compensation by 25% if there is a successful claim and someone hasn't followed the code rather. However, where we're now at is the current government thinks that this is inadequate. It promised to abolish the practice of fire and rehire. And so the basis on which you can dismiss an employee and offer them new terms and conditions, rather than just terminating the contract full stop, is going to become much, much harder, even when it is dealt with as a last resort, and that employees therefore will probably find it much easier to just dig in rather than agree voluntarily to a change to terms and conditions. I know that we are still waiting for further details in respect of lots of things. The consultation on fire and rehire closed at the beginning of April in respect of some bits and pieces. So there's a few bits that are still watch this space, but certainly it's one where we're not quite getting as many queries as we are on some other areas, but that doesn't mean that as a group of people we can ignore the fact that this one is coming, as there are a lot of things that potentially one can do now and one should be thinking about doing now. So I'm going to hand over to Laura to discuss what you might need to be able to do now before we look at how and why you need to be able to think about making changes in the future and what won't be possible come 2027. So over to you, Laura, and next slide, please.
Thanks, Hilary. Just to say before I get started as well, if you've got any questions while we go through, please feel free to put them. I think we might have a Q&A box. Yes, we do. So we'll cover any questions at the end. So before I get into what the changes are, I just wanted to go through the current law and how fire and rehire works today, in case you haven't come across it so far. As a union-backed party, it isn't perhaps surprising that Labour are targeting the use of fire and rehire, which is more politely known as dismissal and re-engagement. So to start with, looking at the current law that currently governs dismissal and re-engagement and how it may be used. So you may be aware that currently employees have the right not to be unfairly dismissed after 2 years service, though there is another change coming in 2027, so that will become 6 months. Unfair dismissal has two branches. You've got the reason for the dismissal and also the procedure used. For a fair dismissal, employers must rely on a fair dismissal reason, such as redundancy, conduct, capability, contravention of a statutory restriction, or some other substantial reason which justifies the dismissal. A fair process is usually, depending on the circumstances, consultation, discussion with the employee over a number of weeks, involvement with trade unions or collective consultation if needed. If you want to change an employee's terms and conditions, what are you supposed to do? So for minor changes, it might be allowed by a term in their contracts. There might be a variation term which allows you to make changes. However, if you're proposing a major change that staff may not be happy with, I can tell you that to rely on a variation clause in those circumstances would be very, very risky. Firstly, that the courts generally interpret a clause against the party that's seeking to rely on it. And historically, the courts have held that a general flexibility clause is very unlikely to be sufficient to allow an employer to make a change that is to an employee's detriment. Secondly, an employee can argue that you have committed a fundamental breach of their contract of employment and seek to claim constructive unfair dismissal. If the risk is a claim anyway, the sensible approach has always been to minimize that risk and go through a consultation process. Fire and rehire, dismissal and re-engagement has a bit of a nasty reputation. There have been some big news stories, as Hilary mentioned, about employees using it. Centrica, Tesco, and probably most famous of all is P&O Ferries. So what the current process looks like, it tends to arise when an employer is looking to implement a change that may not be agreed voluntarily or may not be agreed at all. So recent examples that I've dealt with personally tend to be a change from a work from home arrangement. So we had an employer whose staff all worked from home contractually and moving them back into an office workplace, a reduction in pension contributions or removal of key employee benefits. So generally speaking, an employer will usually commence consultation collectively if needed about the proposed change, explain why it's needed and what it will mean, and engage with the employees on any alternatives. Hopefully, an employer is able to get voluntary agreement to the change, but if not, a dismissal and re-engagement process may then follow. It ends with the employee's dismissal and immediate re-engagement on new terms, with the variation included in those new terms if they agree to the new terms. Usually and hopefully, that's only needed for a very small number of employees if the employer has conducted a good consultation process. As Hilary mentioned, there is currently a statutory code of practice on dismissal and re-engagement. Broadly, it pretty much covers what we would always recommend, which is following a fair process, engaging with staff in consultation and explaining the reason for the variation. It's not legally binding, but as Hilary said, it can lead to an uplift of up to 25% to employee compensation if it's not followed, and that is going to remain there. So moving on to the new law. So it was originally proposed that it's going to be automatically unfair to dismiss someone either for refusing to agree to a variation in their terms and conditions of employment, or in order to replace them with someone on varied terms and conditions doing substantially the same activities. And it didn't previously matter with the original proposal what the nature of the proposed variation was. As you can imagine, and as Hilary alluded to, that would have been a huge restriction on employers. As a reminder, automatic unfair dismissal usually means there's no length of service requirement, not always, but usually, and the employer does not have the chance to justify the reasonableness of the dismissal for that reason. So in the case of fire and rehire, there is going to be no qualifying period in order to bring a claim. It won't apply to employees who've not yet started work. But yes, in theory, it does mean an employee on their first day could bring a claim if an employer sought to dismiss and re-engage them. As the slide says, the proposed change is due to come in on the 1st of January 2027. And the new right is going to mean that and it will be an automatically an unfair dismissal where an employee has been dismissed for refusing to agree to a restricted variation, or where the dismissal is to enable re-employment or new employment on same or substantially similar work on a varied contract where there is a restricted variation. Under the amended provisions, so slightly watered down from what they had originally proposed, the new right is only going to apply where their proposed variation is a restricted variation. It's still a significant restriction on employers, and it isn't just capturing those probably more famously unscrupulous examples like P&O ferries, i.e., mass firing and rehiring. It is going to significantly impact employers' ability to make changes to terms and conditions of employment, possibly also an employer's ability to replace a dismissed employee with another employee on different terms because of that second part of the test. If someone is dismissed for not agreeing to a change, or if someone's dismissed because you want to employ someone on slightly different terms. So what is a restrictive variation? If we can move to the next slide, please. So restrictive variation, they are described in detail in the legislation, but broadly it's going to cover pay and performance, including benefits. Such as pension, contractual bonuses, working hours, holidays. The wording does also allow the government to later specify further restrictive variations. It's important to note that some common changes, such as place of work or changes to employee duties, are not going to be covered by the legislation, meaning the usual unfair dismissal process. But do be warned, even if you are not proposing to dismiss for a restricted variation, an employment tribunal will still look at the fairness of that decision. And there is a exception to all of this, and that is going to be financial difficulties. Thank you. So employers can only impose a variation if the reason is to eliminate, prevent, or significantly reduce / mitigate the effect of financial difficulties, which at the time of the dismissal were affecting or were likely in the immediate future to affect the employer's ability to carry on the business as a going concern. In all the circumstances, the employer could not reasonably have avoided the need to vary. That is quite a high bar to meet. We'll have to wait and see how some of these points are dealt with by the courts. For example, how are they going to expect employers to evidence that the change will mitigate the effect of financial difficulties? And how immediate is the immediate future? The exception also isn't also just that it will cause financial difficulties, but that the financial difficulties are so severe that they are or were likely to impact the employer's ability to continue as a going concern. I can already think of how this would impact changes. For example, we work with a lot of independent schools wanting to leave the teachers' pension scheme. So, how would you evidence that that's going to cause financial hardship when the employer contributions, which will be the financial difficulty, are subject to change? You may not know what level they will be in the future. I'd also expect that those with unionized workforces or just employees in general tend to be much more well read on the law, or thanks to AI they are well read on the law. So I can expect a lot of pushback from unions and employees demanding evidence of financial difficulties, and I can't imagine employers going to want to share evidence of financial difficulties, in which case, an employee or a union might then argue that it's a restrictive variation. Still, a fair process will need to be followed regardless. So, meaning consultation with staff, and a tribunal is going to look at anything that is offered to the employee in return for agreeing. Next slide, please. As mentioned, non-restricted variations can be made, but an employer would need to consider very carefully whether the variation counts as restricted, and may need to be prepared to respond to an argument that the change is a restricted one. Non-restricted variations are still going to need to be made in accordance with the current unfair dismissal law, so it will need to be done fairly with a consultation process. This isn't a new sort of cause of action, new claim per se. It's just being covered within the existing unfair dismissal legislation. generally, I mean, Hillary's going to cover practical advice, but as all matters involving consultation, engagement with staff and unions is, if applicable, is going to be really key to avoiding issues with this. I'm going to hand over to Hillary now, who's going to cover the practicalities of this and how to deal with it.
Sorry. So thank you. There are a number of areas where we can already see battlegrounds coming up. So the provisions that we've been talking about, they're quite complex. So this is not unfair dismissal as we've been used to it. We're having to think about, well, is it a restricted variation? What's going to happen? What is pay? And we're still waiting for some information in respect of that, as Laura has touched on. But there are going to be quite a lot of pitfalls that come into place in respect of that. So what the first big takeaway that I think we've got to say is that anyone who is looking at changing terms and conditions, harmonizing terms and conditions on an acquisition or something similar, or restructuring in any way at all, is going to certainly need to spend some time familiarizing themselves with these new rules. And it's quite likely there'll be some specialist questions as we work things out. Also, because it's new, there'll be things as we wait for case law, and we have to think about what this actually means. But the Employment Rights Act is going to fall far short of banning the fire and rehire outright, which is what we initially thought that they were going to do. So what we've actually then got to think about is this a fire and rehire scenario that you can lawfully do? Because sometimes there might be things that are potentially permissible. So if you are in a situation with an employer where there is an economic justification that threatens its existence, or there's a slightly different test if you're in the public sector, which is a parallel test, and the reason for the change is a restricted variation. But the fact that this is not black and white means that the battleground is almost guaranteed to be about what actually is really going on, because the circumstances where you can do the dismiss and re-employ are going to be significantly narrow. So do you go to an employee and say, actually, can you agree to this change to your contract? And do we look at that as a voluntary exercise? Because then what will happen if you might have done that, even if the employee has agreed to that change, but then very shortly thereafter, they might be dismissed for performance and they might be replaced for somebody else who's on a different set of terms and conditions. And it doesn't necessarily have to be a less favorable set of terms and conditions. It just has to be something where one of the terms is different, and the term that is different is a restricted variation. Is that going to be automatically unfair? Because it might be automatically unfair if you've got a restricted variation, even if there isn't really something that comes in respect of that. And at least some of the commentary is suggesting it's going to become very, very difficult, if not quite impossible, to hire replacements on different terms in those restricted variations. So often we have got examples, and we're using examples in respect of this across the board with things like football. So if a football manager, can you dismiss someone on a poorly performing football manager and bring in a new one if they're not on identical terms? Is that going to be something that's going to get caught? The other thing that is inevitably going to happen is that when employers want to change terms and conditions, and we do spend quite a bit of time thinking about variations to terms and conditions, the potential exposure, particularly to unfair dismissal and automatically unfair dismissal claims, is going to be much higher. So that's going to be much more complicated on reorganizations, acquisitions, outsourcing, things along those lines, because it's usually the terms, particularly things in connection with pay, but also things like hours and holiday. They're the ones people are often looking to try to harmonize in those circumstances. And they're the ones where actually we see the biggest use of hire and refire, fire and rehire terms anyway. There are some places where it probably will be easier. So I mentioned relocation on the slide, and relocation is not in a restricted variation term, but we are going to see probably arguments much more on closures of one place of business and moving to another, or even relocating people back in to the office. And it probably is therefore important to at least audit and review contracts to see what flexibility you might have. So it might be sensible to look at those mobility clauses again, the ones that say you may be required to work anywhere within the region of Greater London, you may be required to work anywhere within the UK, because then you might still have, well, actually, it's not a variation to the contract if you ask them to move, but we have to think about the implied terms. And that's another place where I think we'll see quite a lot of case law coming through, because the requirement of, is this a breach of the implied term of trust and confidence, is going to come in. And then whilst mobility is not a restricted variation, if then the people who are not moving are re-employed on different pay, for example, because they're in a different area, what's the reason for dismissal? Is it redundancy? I think it probably would be at the moment, and an employer would probably plead it was some other substantial reason. But the question's going to be causation. Is it causation because you need to move your site from one place to another, or is it causation because you're going to try and reduce the amount of pay? Because if you move people to a different part of the country, offshore, whatever else it may be, then the pay change might mean that there's arguments that this becomes automatically unfair, because the principal reason will be to enable you to employ another person or re-engage a person under a varied contract, doing the same duties, doing substantially the same duties as the employees in place A carried out before the dismissal, but they're paid less because they're now employed in place B. And I think that's the central problem, that when this was being introduced, people were thinking about employers seeking to impose less favourable terms and conditions, like they did with P&O. But there is a question as to, well, what is less favourable? How does this work? Where is this going? But also, what happens when it's not actually about cutting pay and benefits, but that is the effect? And that is where I think we are going to say the argument. Similarly, what happens where it's automatically unfair dismissal because it's a restricted variation, but it might not be a fundamental term? So if you're changing someone's hours of work, is that fundamental? Well, it might depend on the circumstances. If you're changing their holiday or even potentially holiday years, is that actually one where we're going to find ourselves in difficulty? Because again, it might prove to be automatically unfair. Redundancy consultations I've touched on before. At the moment, we're all used to, you do a redundancy consultation. As part of that, you have to be seen to be offering suitable alternative employment. But what if an employee is asked to consider a restricted variation as part of that consultation process? The cynic in me thinks it will just mean that everyone's pushed to make redundancies more quickly, because you don't want to have an argument about whether this is a restricted variation. Going back to where we started, where some of this all came from, outsourcing, the kind of P&O type scenario. What happens if you're replacing employed staff with non-employees, like agency workers, or you're outsourcing staff to an agency? The activities, if they're the same or substantially the same, then that is still potentially something that we have to consider as a restricted variation, except in this case, you don't have to pay much attention to what's being offered in return. What if you're trying to replace someone with a self-employed contractor on the proposed varied terms? That's not likely to be permitted. And we haven't got the time limit, not the time, we haven't got the clarity in respect of where some of these things will come through. What we do also have, and this is the point about time limits that I inadvertently moved into, is that the cause of action, when does it actually arise? Because if you're dismissing somebody and you may be looking to replace them, outsource them, have an agency worker, move something along those lines, the normal time limit at the moment, 3 months from the date of dismissal, increasing to 6 months under the Employment Rights Act later this year. But the cause of action may not arise until the replacement is in fact employed on different terms. And we don't quite know how that's going to work in respect of the time limit. So the fact that this is not black and white is probably a good thing, but it leads to lots of grey areas where we do envisage problems. So one of the reasons for doing this now is to have the action points, which what do you do now? And this is the next slide. One of the things that we are saying very clearly, if you already know you want to harmonise terms and conditions, you'll know you're going to need to make changes, it really should be done now, because it's a lot easier now than it's going to be in January next year. Also, it's worth actually considering making sure that you are managing and dealing with those poorly performing employees. Also worth doing that in any event because of the other changes on unfair dismissal. There's going to be this major block on looking at changing what might be considered outdated or even unprofitable pay, pensions and hours structures. And I'm aware from some of the work that we're doing, some of those are still in place. So it's worth actually thinking, what do we do now? What you might then need to think about is you will still be allowed to hire new recruits on different terms. You will still be allowed to make pay rises conditional on agreeing to a change. But what you can't do is terminate existing employees in order to impose the change to the core terms, unless you've got that financial collapse. So we're going to end up with a risk of a two-tier workforce, which raises challenges both in practice, in industrial relations circumstances, and for administrative issues. So we're very strongly saying, audit your contracts, see what you've got, understand what they say about shift patterns, working patterns, holiday, pay, expenses, benefits, workforce practices. If you know that there is already a problem, even though these changes aren't going to be implemented until next year, we're already in a place where there is reputational risk. So look at variation clauses and whether they need to be reviewed. They will all still need to be exercised reasonably, and it's not a cure-all, but it is a start. Make sure that anything on pay that's bonus, commission, other remuneration issues have not become contractual, and make sure you include the powers to vary. There is also the interesting thing for the lawyers who are looking at this is that TUPE might get suddenly a lot easier, because if a dismissal is for a restricted variation on a TUPE transfer, it's going to be automatically unfair anyway. So we don't need to pay attention to ETO reasons and ETO defences. But that does mean, please think about, if there's a harmonisation, the one real takeaway I have from here is do it now. So that's really, I think, where I would take it from here on this particular part of what do we do with the Employment Rights Act. We have one question, well, I had a couple of questions sent in advance. And whilst they don't necessarily relate to this as such, one of the questions that we are getting, which has been also sent in advance, is what changes should employers do to manage probationary periods as standard in 2026? And Laura, I don't know what you think. I think I'm now getting to make them 3 months, review them at 5 months, don't extend past 6 months, make sure you've made that change now. This will apply from July. So certainly that's the advice we've been given. I'm assuming, Laura, you're getting the same number of questions we are.
Yeah, absolutely the same. And it is particularly problematic for some industries where they tend to have longer probation periods. For example, in the independent school sector, where they tend to have 12 months. But you get to a point where you want to review probation after 12 months, and you'll have to be live to unfair dismissal rules. So yeah, no, we're advising the same in the clients I speak to as well.
Okay, and just the last question we had sent through about breaks of service. It's one of those where I will say that's really difficult because we don't know how it's going to work on the time limits. So that where we know that we've got a time limit at the moment, we know the time limit is being extended. What we don't know is when this becomes law, how long you have to leave it before you can re-employ somebody or re-engage somebody or employ somebody else to do the same job. I think it is going to inevitably, it's going to be at least 6 months. Don't talk to any of us about the delays in the employment tribunal system, because we're finding notifications from the employment tribunal system is coming through much, much more delayed than they ever were. And what I would say in respect of that is at least 6 months, but as long as you possibly can without damaging the business, is my personal view. Laura, I don't know again if you have anything to add.
No, no, nothing to add. We have got I know we're at 10:01, but we've got a question that's come in. So someone said they're looking to change the days of the week that an employee works, but the same contractual hours. I think a lot of that's going to depend on your discussion with the employees and whether this is something that they are requesting or something that they are in favour of. If it's all everyone's happy with it, then it should be nice and simple. But if it's a request that might not be quite so well received. The advice would obviously be to look at that now rather than later. In terms of whether that changing the days of the week, I mean, I suppose that could be covered as a restricted variation. Hilary, I don't know if you've got
I mean,
any.
I think it probably will be, because it
Mm,
will be changing hours.
yeah,
Because most contracts, I mean, I guess it depends exactly what your contract will say. And then say, well, actually, where does that work to? And I know you've added a follow-up in respect of that, from 5 over to 7 to include weekend working to match operational requirements. I think that is likely to be considered a change in hours. But
yeah,
even if it wasn't, then I think we have to think about that from the ordinary principles and where does that get to. So very strong advice is get that change sorted out and deal with the consultation now rather than delay until January 2027.
yeah,
And
absolutely.
I'm going to say I am mindful of the time, so I will thank you all very much for joining us. I will remind you that we're continuing this series on our HR insights, with so much going on with the Employment Rights Act. I think the next two are also going to be covering other changes which we are anticipating and what people should be doing now. So thank you very much for your time.
Thank you.